I'm Jeff Harrison. I'm here on behalf of Mr. Bigelow. He's joined me at the table.
All right, thank you. We are here today for a final pretrial conference. I did not meet with counsel and chambers on this file, did I? No.
We did not. There is no resolution to this.
Okay. 1 second. Mr. Bigelow. I'm just taking a look. All right. I have this conversation with everyone on final pretrial days when they do not enter a plea. What I'm about to say to you is not a position. I don't have any opinion about the charges, whether or not you are or not guilty. I don't know what the evidence is. I just can see what the charges are. I have no opinion about what you should do or shouldn't do. So don't read into it. The reason I have a policy that says today is the last day to enter a plea, or you do a trial, or you can plead straight up as charged. That's not to pressure you to do anything. It's to hold the two attorneys to their ethical and professional duties and responsibilities to make sure that they have done all they can as negotiators to the best deal they can. So that way, you know, the deal's not likely going to get any better because Judge Elmore won't let it. So that means the prosecutor has knowingly put out her best offer. And you and your attorney have talked about it, and you know Mr. Harrison is arm wrestled her and swung and all that, wrestled with their thumbs, and he didn't win. And that way, you know, it's going to trial. So it's really to put some finalization so you know what's going on. And it's also because we have to bring in 60 potential jurors. They all have to take time off of work, get people to watch their kids or watch grandma and grandpa or whatever. And they have to subpoena witnesses, and other people at the time take time off of work, and I have to push other cases away. Before we start all those wheels working, I make them do this job. Now, with all that said, I know what date your case is set for. It's trial on February. I said that and I don't know now. Hold on.
It should be the 10th.
The 10th, yeah.
For this cycle.
So what happens right now, sir, is we already have another case. It's probably going to be a 3-day long trial that's going to go. It's the older case, which means there's a strong likelihood yours won't go to trial. And theoretically, even though we use these called final pretrial conferences, the word final has an asterisk next to it. Because if your case does not go to trial next time, it will come back for another final pretrial conference and it will have another trial date.
Just for the record, I have one witness who's not available.
Okay.
Trooper
For the 10th.
Well,
for the 10th.
if something, but so here's what I do. I'll still leave yours on the docket as if it's going to go to trial, because the other case might have a witness who all of a sudden can't come because they've had a death in the family or a car accident or something. Then all of a sudden, I don't want to lose that trial date, so I'm going to slide yours in. Or the police officer, the trooper, may not go to whatever he's going to do, a training, a conference, a vacation, I don't know. So what I do is, because I'm in charge of managing this courtroom and the docket, and I don't want to lose a trial date. If I lose a trial date, that's 1 out of 24 trials in a given year covering 2 counties that I just lost. I don't like to lose those because it's important to the people of Western Missaukee County. Now, I just did a lot of talking to say, your case is going to go to trial. You're listed as number 2 for February 10th. The other case, because I know the case very well, is not going to result into a plea deal. It's going to go to a trial. Yours won't go. However, I'll make that final decision probably a week prior to. Because over the next week, let's say an emergency happens and I no longer have that trial, then I'm going to slide yours in, unless there's a problem with the witness. So right now, I expect going to trial on February 10th. You'll actually know whether or not you will on probably by February 11th or 7th.
So,
Okay, and there's a high likelihood that yours will not go to trial. We all know the other file very well, and it's likely to go. Thank you very much. You have any questions for me, sir? All right, good enough. Anything else, Ms. Carey?
No, thank you.
Anything else, Mr. Harrison?
I'm satisfied with the record, Your Honor. Thank you.
So am I. Good. We're adjourned. Fine. Continues. Maybe we'll see you on the 10th. Maybe we won't. Thank you, sir. Nothing such as bad weather, just bad clothing. So, I don't know. Appearances from counsel.
Morning, Your Honor. Assistant Attorney General Sharon Park on behalf of the people.
Thank
And
you.
I'm Jeff Harrison. I'm here on behalf of Mr. Hunt. As usual, he's joined me at the table.
Thank you very much. All right, folks, we're here today for another final pretrial conference. I'm not going to go over the history of the file. Counsel and the court and Mr. Hunt are well aware of it. So all I need to know today is, what are we doing?
At this juncture, Your Honor, we would intend to proceed with the trial as scheduled, which I believe is February 10. Barring any difficulty that poses for opposing counsel, we didn't really discuss that.
Okay, hold on. All right, Ms. Park, anything to add to that?
Not on that matter, Your Honor.
Oh, you have
People are
another one?
prepared to proceed for trial. We had extended an offer
Okay.
that I believe is being rejected at this time.
I assume it is. All right. Mr. Hunt, I know we talked about this before. I say this though every single time. Today is the last day in which to enter a plea. That is not to put any pressure on a defendant. It's to put the pressure on the attorneys and hold their feet to the fire to make sure that they are the ones that are processing the case appropriately. And so what I know today is they have done all their arm wrestling, arguing in the back rooms, in the alleyways, and they can't resolve it, which is fine. I don't care. You need to know, I need to know, my staff needs to know, witnesses need to know, potential jurors all need to know. We are going to trial. We all need to get juror subpoenas out. They all need to get witness subpoenas out. We need to have experts and witnesses and jurors all take time off from other jobs and duties to come here, which isn't at all a bad thing. It's all a good thing, but I just need to know before I set all those wheels in motion that there is no resolution. Okay. All right. Bond continues. I've never had an issue with Mr. Hunt. He's been here every single time. Therefore, bond continues. Now, I do recall that wasn't there a motion?
Well, it's my understanding that people have essentially withdrawn the request to introduce the evidence, thus rendering the motion moot.
Okay, and that piece of evidence was allegedly an image,
Correct.
a photograph or image of something that would depict potentially inappropriate conduct of somebody, not the defendant, but of somebody else, something like that. Is that right?
That's correct, Your Honor. So the people will be withdrawing that notice on that particular
Okay.
piece of evidence, but
Yeah.
not the previous other acts notice that was filed.
Correct. Right.
All right.
That's the point worth making.
Okay, copy that. Therefore, the motion filed by the defense is moot. I do not need to issue any ruling because it's withdrawn. Based upon the communication between the parties and moving forward, I wouldn't accept an amendment to add to the witness list because we've already dealt with it, at least from that point. All right, was there any other? You asked for an amendment for witnesses and exhibits, Mr. Harrison. Was it just for
It was
that
just
subject?
to add that expert to refute that particular point.
Got it.
I don't have any intention of calling him. So again, the request, everything else is likewise moot, I believe.
All right, thank you very much. All right. See you all in a couple weeks.
Okay, thank you, Jim.
Thank you, Your Honor.
We're adjourned.